All right, I want to call this exciting event to order. The turnout here is wonderfully reflective of what a special community we have. I have a few initial remarks and a few introductory remarks, and I'll turn it over to Chris McKee, who's helped work with the Barristers Council. First, we have a dream team of Bryce, Holly, and Shaylin. Where are each of them? Let's give them all a round of applause. It takes a lot of work to put this together, and with great appreciation to them and to Chris, we have helped evolve and enhance the Rothgerber Moot Court competition. This competition has a great history. There is a long list of prior winners. We invited a number of them here today. We are excited to generate some new winners today. We have some pretty wonderful advocates here on both sides, and we have an awesome bench to test their mettle. I want to thank Wheeler, Trigg & O'Donnell. Carolyn Fairless is here, one of our fine grads. She's the managing partner of that firm. Did you compete in the Rothgerber?
I was president of the Moot Court Board in 1998.
So here you have it. This could be you. Wheeler, Trigg & O'Donnell, really one of our nation's finest firms when it comes to trial advocacy. Morgan worked there as a paralegal before she came here to law school. A number of you should, at the reception, make sure to talk to Carolyn and get her wise counsel and thank her for the reception that they're sponsoring. For those who don't know the name Ira Rothgerber, it's worth remembering that he is one of, if not the most generous benefactors of the law school. The old building, the Fleming Law Building, had a Rothgerber library that Ira named. This competition Ira named after his father, who was a judge. You can read about that in the program. And each year, our goal is to get fine advocates to test their mettle in front of a bench of really talented jurists. I will mention who these jurists are and then turn it over to Chris for his introductions and thank you. First, close to home, Ben Coates on the Colorado Supreme Court, a grad of Colorado law, has been tremendously engaged with the law school, hiring clerks and being a great friend to the law school. Also relatively close to home, Judge Nancy Moritz, who's on the 10th Circuit. We strongly encourage all of you to think about the opportunity of clerking, not only on the Colorado Supreme Court, but in nearby states like Kansas, where we occasionally will find willing folks to apply and get opportunities to work. And if people are willing to stretch a little bit for the chance to clerk, it is a phenomenal entree into one career as a lawyer. If you don't believe me, you can ask Carolyn afterwards about the value of judicial clerkships. And finally, Steve Higginson, whose connection to Colorado is the most attenuated, but nonetheless quite profound. He clerked for Justice Byron White, who many people here know as the name for our Byron White Center for Constitutional Law, the Byron White Courthouse for the 10th Circuit, and really a inspiration here at CU, where he was an undergrad who was a scholar and an athlete in a sense of the word that is hard to communicate, given that he did win the Heisman Trophy, did eventually play pro football, was a Rhodes Scholar, was a Supreme Court Justice, and I, like Judge Higginson, had a pleasure of working for him. Justice White is a inspiration to all of us. For those who want to know more about Justice White, there's some Justice White memorabilia over at Folsom Field you can go check out, or down at the 10th Circuit. So without further ado, you're here on this exciting event. Let me let Chris McKee warm it up and introduce our panel.
I want to echo what the dean said about thanking everybody for being here and for having this be such a great turnout. There are a number of 1Ls here who I know you are highly encouraged or required to be here, and you won't be disappointed. This is really one of the most important events that we do in the law school to celebrate internally the quality of our students in the student competitions. And student competitions really is one of our core experiential learning opportunities, and it is open to everybody to participate in. There's mock trial, there's moot court, there's transactional, and so here we are today at a moot court event, and so hopefully next year or the year after we'll be looking at one of you who are joining us here sitting in these tables as petitioner or respondent. I want to also thank the competitors for being here. And I want to thank those competitors who participated in the preliminary rounds where that field was winnowed to the 4 that you have here today. But it was the strength of all of those competitors that made the competition special this year. And we actually have gone back to doing the preliminary rounds based on really some discussions over the last couple of years with some past Rothgerber recipients of trying to resurrect this to be a true competition in which we have preliminary rounds, brief writing, and then the oral argument. So I want to thank those members of the community who've come to the dinners and competitions in the last couple of years because you have made this competition better this year by us doing that. I want to thank the faculty members who are here and that encourage their students to be here. And with that, we will come back and do some more thanks while the judges are deliberating. But the last plug I want to say is that I hope that you stay for some of the comments of the judges following the arguments. They'll briefly address the argument and announce a best oralist and a best team. And then we will then retire to the Rothgerber reading room in the library for a reception. And there's great memorabilia there for past moot court competitions. There's some cups, the Scott Cup. There are names and plaques up for past Rothgerber recipients. So I hope everybody here comes to the reception that follows. And with that, I will go ahead and just invite the judges to come in. When they are seated, they will call the case to order and launch right in. We'll do a little bit more maybe back and forth with them at the end. Yes. I will. Sorry. I actually had asked for that so that I wouldn't do it again this year. Thank you, Mike. All rise.
Please be seated. Is that for me?
Yes.
Well, it looks like we have one case on our docket this afternoon. The case of the United States versus D'Onofrio. Each side's going to be allotted 30 minutes. We understand that you're going to divide your arguments into 2 primary segments or issues at 15 minutes each. We'll try to generally ask our questions that are oriented toward the right lawyer. Petitioners, attorney for the petitioner, when you approach, or actually for all of you, when you approach, I'd like you to introduce yourselves and indicate for the record, assume we're recording, which party you're representing. And there'll be a timekeeper, and you have a light you can see, so you watch for your own time. And the time will begin when the petitioner begins to speak. When you're ready.
Good afternoon, Your Honors, Mr. Chief Justice, and may it please the Court. My name is Dylan Roberts, and I, along with my co-counsel Andy Ball, are representing the petitioner in this case, the United States government. I will be discussing, there are 2 issues at bar today. I will be discussing the tip reliability issue. My co-counsel will be discussing the federal rules of evidence issue. Your Honors, what we are asking the court to do today is fairly simple, and that is to enforce this court's own precedent from Dirks versus SEC and reverse the ruling of the 13th Circuit and reinstate the ruling of the district court, because the district court precisely followed this court's guidance when it comes to defining the personal benefit needed for insider trading and the level of knowledge needed by the defendant to be held liable for insider trading. When reviewing jury instructions, an appellate court reviews those de novo.
You say follow Dirks. Dirks was 50 years old, and it doesn't seem like anyone's been able to follow Dirks. It was a civil case, and there we reversed. the censure imposed on the tipper, didn't we?
You did, Your Honor. And you're right that Dirks is an old case. However, circuit courts across the country have always used Dirks as the guide when it comes to tipper-tippee liability. In this case, it's still the standard when it comes to defining the issue that we have here today, which is the definition of the personal benefit and the knowledge a defendant must have of that personal benefit. And you did note the difference between the civil and criminal nature of the Dirks case, and what we have here today is a criminal case. However, Dirks, just like this case, was interpreting the Securities and Exchange Act, which the respondent was convicted under for insider trading. That act specifically does not address any difference between civil and criminal liability, and it does not address the mens rea needed for somebody to be held criminally liable. And circuit courts across the country, as I noted, have taken up criminal cases using the Dirks standard. For example,
But there's a split, right? The Ninth Circuit and the Second Circuit. The Ninth is pretty clear, so it hasn't been clear for the circuit courts. We have confusion out there. And again, in Dirks, the censure, we overturned the censure. So you're really relying on dicta in Dirks to impute liability to a tippee down the line that didn't even know the original tipper, didn't ever meet him face to face. So it looks like the government's grabbing onto dicta to create a rule not tethered to money and property and not even tethered to scienter by the target.
well, Your Honor, I would say it's not that we're completely grabbing onto dicta. It's that in Dirks, the defendant was found not to be liable of insider trading. However, the court still articulated a standard that can be used when determining whether somebody could be liable for insider trading. So it created a standard, found that the defendant in that case, Mr. Dirks, was not liable using that standard. But circuit courts have used that same Dirks standard for every year or years after the Dirks was decided. So that's what happened in this case as well. So specifically, this court should overturn the ruling of the 13th Circuit for two reasons. First, this court's decision in Dirks is the proper definition of what a personal benefit can be when it comes to matters of insider trading. And second, the 13th Circuit ignored the constructive knowledge requirement that this court allowed for in the Dirks decision when it said that a defendant must have actual knowledge of a personal benefit in order to be held liable for insider trading. And to have that standard would to create a system that would reward sophisticated traders for their conscious avoidance of the truth when it comes to sensitive market information that they know.
What support is there for constructive knowledge being an element in a criminal case? Isn't that really, I mean, it's kind of a negligence type standard, isn't it?
It could be a negligence standard, Your Honor. However, there's also the willful avoidance standard that is used in criminal cases, especially like this. The United States versus Newman, which is a case that is very similar to this from the Second Circuit, talks about the willful avoidance, and so does United States versus Zhao from the Second Circuit.
Tell me how that willful avoidance, how that applies in this case.
Well, in this case specifically, the respondent here is claiming that she had no knowledge that the original tipper, Mr. Abernathy, gained a personal benefit when he disclosed the information to Mr. Bookwalter. However, the facts are very clear from this case that she was at the exact same birthday party of a family member when that information was disclosed.
Well, she had knowledge of a relationship, but does that give her knowledge of a personal benefit? Aren't those two different things? And I'm not understanding your argument on that.
It's our contention, Your Honor, that that should be a question for the jury, as it was in this case. The government was allowed to put on knowledge under the Dirks standard, to put up evidence that a jury could infer beyond a reasonable doubt, which is an extremely high standard, that she reasonably knew or should have known that there was a personal benefit being gained when Mr. Abernathy gave the information to Mr. Bookwalter. So the Dirks court, this court, gave that constructive knowledge requirement, and district courts across the country have used it in their jury instructions, as they did here today, not saying that we have to know for sure that she knew of the personal benefit, but that a jury could reasonably infer that she knew or reasonably should have known.
Could I back you up just a second?
Yes, Your Honor.
With regard to the willful avoidance, how do you, maybe you could explain in greater detail how you see that as equating with a negligence or reasonably should have standard?
Well, Your Honor, it equates with negligence or a reasonably should have standard in that We're dealing here with extremely sophisticated traders. The respondent in this case has worked at several hedge funds and currently worked at when this happened, worked at a multi-billion-dollar hedge fund. She knows that sensitive market information such as this, that through a company's stock price in great flux, is extremely sensitive and confidential information. And at trial, she tried to, and through her appeals, has tried to say that she simply didn't know where the information came from. We believe her specific knowledge of how this type of information can affect the market and how she can greatly profit from knowing this information shows that she can just simply feign ignorance when it comes to knowing where this information.
Actually, probably not feign, would it be? You mean could actually arrange it so she was ignorant or knowingly be ignorant?
Of course, she could. You're absolutely right, Your Honor. She could just insulate herself from the information by simply putting a person or two between herself and the original tip.
And perhaps I could follow up on that, just that. And is that the same knowingly or willfully remaining ignorant, avoiding from learning something? Do you see that as the same as failing to know something that a reasonable person would know?
Your Honor, I believe the facts in this case show that she absolutely should have known the effect of this information and that this type of information would not arise, or she would never come across this type of information if it hadn't been for a breach of fiduciary duty that Mr. Abernathy committed when he gave the information to Mr.
Let me ask one
Goldwasser.
other about the structure of your arguments, and I'll let you get back to where you want to be. Given these two issues and the way the 13th Circuit decided them, would it be fair for me to say that if we were to decide that the trial court did err with regard to the standard of culpability, or the reasonably should have known, that we don't have to proceed to the second question because that would require that would end the case?
I believe, Your Honor, that we need to first determine whether there was a personal benefit and then move on to whether the respondent or any criminal defendant in a case knew or should have known about the standard.
And that's even if the trial court erred in instructing the jury with regard to a wrong mental state. Is that right? Is that what you're saying?
Yes, I believe so, Your Honor, but we need to, once the personal benefit is defined, then that becomes the key issue here, as it was for the jury in this case. So I believe you're correct in that assumption.
But what's the parade of horribles if we just adopt the Second Circuit, which is the most experienced court in this area? They're just saying if you want to rely and build a case on gift liability, where your whole theory and your state of mind as to the eventual tippee is that we're going to impute that they knew the insider misappropriated, even though they never met or never spoke to that person, then at least the relationship that originated, it's got to be meaningful and it's got to have some pecuniary quality. That's a small adjustment, and it seems to prevent over-criminalization of any casual encounter.
I believe, Your Honor, that the parade of horribles and what the United States government is trying to prevent is the exact reason for the Securities and Exchange Act. If you look at the legislative history of that, it was to specifically block sophisticated traders from.
But this lady's not sophisticated. She went to a grandmother's party. That's the only encounter she ever had with this insider, right? And the grand jury wouldn't even indict the first time. And then, no fault of the government's, but 2 people in the chain die and another one gets dementia. So this just looks like an incredibly thin case, and the 13th Circuit recognized that.
Your Honor, it's our contention that she is a sophisticated individual, especially in this field. She works at a multi-billion-dollar hedge fund, and her trading on this information saved her multi-millions of dollars in potential
But there's nothing
losses.
criminal about being sophisticated at your securities work.
Well, Your Honor, it's our belief that when a sophisticated trader comes across an information that such as an earnings report is going to be significantly down from market expectations on a Saturday afternoon at a social event before it's released on Monday afternoon to the public.
Yeah, but every single prosecution is built on a Section 2 aiding and abetting, right? The guilt is the underlying insider who breaches the duty of fiduciary. So she's not guilty because she happened to get information and use it. You've got to tie her knowingly to his crime, right?
You do, Your Honor, and I believe that's what happened in this case. That's what the jury inferred, at least, and the jury was using instructions from this court that said that you can reasonably assume that a remote tippee, such as in this case, knew of a personal benefit and breached or is liable for insider trading for knowing about that benefit when she trades on the information.
But doesn't that also presume that there's some relationship between the tipor and the tippee, which there was none here? Zero, right?
I would beg to differ on that point, Your
It's
Honor.
removed by two different people in between, right?
If you're speaking of the respondent, however, the issue here with the personal benefit is only as a matter between the original tipper and the original tippee.
True.
Which there is much evidence that there was a close relationship between those two in this case. So for that reason, we believe that there was a personal benefit being gained between the original tipper and the original tippee, and then the information getting passed down through only one other person between that original conversation to the respondent here, that the chain is so closely attenuated that the respondent absolutely is liable for insider trading.
Well, that original close relationship, I guess I'm not necessarily agreeing with you on that. Why do you say that was such a close relationship? They were cousins, right?
Your Honor, I
They
see
saw
my,
each other 3 times a year.
sure, I see my time's expired, if I may briefly respond.
That fine with
Yes,
you?
Your Honor. They did only see each other a few times a year. However, they are related. They're cousins. They often talked at these common social gatherings. They always talked about financial markets. They had a close relationship, certainly when it came to discussing the financial industry and what each other was doing for their work. There's also evidence that Mr. Bookwalter helped, or excuse me, Mr. Abernathy helped Mr. Bookwalter nurture his initial interest in the financial markets and then get into his own business school that Mr. Abernathy went to, and that their closeness in that sense is important here because that's the subject matter that we're dealing with. That is what they always talked about when they got together. They were both involved in the same industry. It's completely reasonable to assume that in the future they may be working together or would come into contact in these financial markets. So for those reasons, and I'll reserve the rest of my time for rebuttal, we ask that this court reverse the ruling of the 13th Circuit and affirm the district court. Thank you.
Good afternoon, Your Honor, Mr. Chief Justice, and may it please the court. As my co-counsel Dylan Roberts mentioned, my name is Andy Ball, and I represent the petitioner as United States as petitioner on the second issue before this court today, the admissibility of evidence under Rule 804(b)(1). The standard of review for questions of law in this case is de novo, but for those questions of law as applied to these facts, reviewing courts should use an abuse of discretion standard of review. Your Honor, we respectfully request that this court reverse the Court of Appeals decision allowing admission of grand jury testimony that was given by a witness that was then unavailable at the time of trial. The Court of Appeals held that this testimony was admissible under Federal Rule of Evidence 804(b)(1). This court should reverse for 2 reasons. First, the motive possessed by the prosecutor during the prior grand jury proceedings was fundamentally investigatory and preliminary in nature. This contrasts with the adversarial nature of trial proceedings. Second, the Court of Appeals decision runs the risk of warping grand jury proceedings into full-blown trial and also runs the risk of admitting unreliable hearsay.
Mr. Ball, let me interrupt you 1 second. So I appreciate your policy arguments here, but do I understand right? You're asking us to construe the scope of 804(b)(1). Is this primarily a construction problem, an interpretation of a rule?
Yes, Your Honor. This is an interpretation of the text of 804(b)(1).
Let me ask you 2 questions about that. First of all, is it certainly an abuse of discretion if you get the law wrong and you apply a wrong standard?
Your Honor, that may be an abuse of discretion. However, the trial court here recognized that the rule requires a similarity of motive and carried their analysis forth with that in mind.
So you're saying it didn't get the rule wrong?
No, Your Honor, I do not think that the district court got the rule wrong.
And let me ask just one other follow-up then. If we are construing a rule, is that like construing a statute? What are the standards? What should we be looking at in deciding what this rule means?
Your Honor, I think we should, it's our position that we should look at the text of this rule. The text requires a similarity of motive. However, when deciding what constitutes a similarity of motive, the circuit court, specifically the Second Circuit, has provided some important features that are helpful when deciding whether a prosecutor possessed a similar motive. In the Second Circuit, the court noted things such as the burden of proof at the prior proceeding, things like whether it was investigatory or adversarial in nature.
But those are all structural. The Supreme Court didn't go with that per se rule in Salerno. Right? Just because that's what the government argued in Salerno, but you aren't asking us to revisit Salerno altogether, are you?
No, Your Honor, we are not. We're asking for a narrow ruling today, a ruling that says that the facts of this case, under the facts of this case, the motive was not similar.
But the district court made those facts adverse to you. So are you asking us to find that he found that Judge Brennan was clearly erroneous in his finding that, well, I've looked at the situation here and the government just had a pretty similar motive, right? You had the same guy in the grand jury twice. After the first time, you didn't get an indictment from the grand jury. So that would suggest to me you would really want to indict him and impeach him. He's not a background witness. He's your target. And you've got the loan information. You've got everything you needed to impeach him. And if you don't impeach him, you're going to get no billed again. So how this case, it would seem like you had to impeach this individual.
Your Honor, if I could take the grand jury testimonies one at a time in response to your question. At the first grand jury testimony, it is true that Mr. Abernathy is key to this potential prosecution. However, after questioning Mr. Abernathy, the prosecutor questioned Mr. Bookwalter. And during that questioning, the prosecutor was asking questions along the lines with suspicion of a broader insider trading conspiracy.
But then you get the guy back in again. Now you've got Ben's testimony already. You've got everything you need to impeach him.
Yes, Your Honor. The prosecutor did have a second time or chance to ask questions of Mr. Abernathy at the second grand jury testimony. At the second grand jury testimony, what we argue is important for this court's ruling today to recognize is that is the questions that the prosecutor didn't ask. And at the second grand jury testimony, the prosecutor he does indeed ask a number of leading questions in the manner of cross-examination. However, at the tail end of that grand jury testimony, the prosecutor asks a question about pecuniary benefit, which Mr. Abernathy denies. However, just 2 questions later, Mr. Abernathy answers a question and says that it's great when family can help each other out. The prosecutor in that case did not pounce on this line of questioning, on this response. And it's our position that a fundamental reason behind that was that the grand jury proceedings, which call for a lower burden of proof, probable cause to secure the indictment, alters the motive of the prosecutor in this case. Now,
but that's true structurally always.
Yes,
so
Your
that
Honor.
would be asking us to revisit Salerno.
Your Honor, we are not asking you to revisit Salerno, although that is an element that is structural in all grand jury proceedings. However, just as Justice Blackmun, in a concurrence to Salerno, stated, this is fundamentally a factual inquiry.
And you lost that.
Your Honor, at the trial court here,
Yeah.
it's our position.
No, I'm sorry, you're right. He let it in. Okay, so he made the factual findings, you're saying. So you're saying he got it exactly right.
Yes, Your Honor. The trial,
So what did the circuit court do wrong? Did they do wrong by revisiting facts themselves, or did they get the standard wrong?
Your Honor, we believe that they did not, they applied the standard of 804b1 too broadly. And this court's decision today should construe 804b1 narrowly. Now, there's several good reasons for construing 804b1 narrowly. First, the Court of Appeals decision provides an incentive for prosecutors for fear that the witness they're questioning at grand jury then becomes unavailable to carry out full and complete cross-examination of a grand jury witness. This runs the risk of turning grand jury proceedings from a fundamentally preliminary step into a replacement for trial cross-examination. The second reason to construe 804b1 narrowly is that 804b1 is already an exception to the rule against hearsay. Now, the rule against hearsay is a fundamental bedrock rule of our jurisprudence. It recognizes that in-court cross-examination is the surest way to ensure reliability of statements and of evidence.
What if he'd said, what if you were investigating a murder case and you put X in the grand jury and he says, Y did it. But then you indict Z. And the defendant, Z, wants to introduce the fact that the witness you had in the grand jury said somebody else did it. Would you be before us saying, well, I didn't cross-examine him enough, and so you don't get to get that exculpatory evidence? You got, in spite of due process clause, exculpatory evidence stays out.
Your Honor, if that exculpatory evidence does not meet the standards of
Doesn't come
804B1,
in.
it doesn't come in. And that's to
Do you even
ensure
owe it in
reliability.
discovery? Do you owe it as Brady, or since it's inadmissible, you don't even have to give it to them? They never know about it.
Your Honor, under 804B1, it wouldn't come in. I can't speak to other cases such as Brady of whether they would be able to see it at all. And the reason it wouldn't necessarily come in, it might come in if the motive was similar. But the reason it wouldn't necessarily come in is because the rule makes sure that this exception prevents unreliable evidence from coming in. And again, if the prior testimony is not fully developed through cross-examination or something akin to cross-examination with a questioner who has a similar motive, then there's no guarantee that that's reliable. There's no guarantee that X saying Y did it is reliable.
Could I just follow up on that a second? I thought your argument was that the failure to cross-examine thoroughly was some indication of a lack of a similar motive. But your last comment made me think you were saying if there is no actual effective cross-examination, then the statement can't come in because that necessarily equates with a lack of motive.
Your Honor, there is a distinction here between opportunity and similarity of motive, and there might be circumstances where lots of cross-examination and something still wouldn't come in. I think this gets back to the idea that this is a fundamentally fact-based inquiry, as Justice Blackmun noted. And that means that the trial court is in the best position to make these decisions from case to case. And the trial court judge will be able to look at what type of questions were asked, what type of questions weren't asked, the burden of proof of the prior proceeding. Was the prior proceeding did it take place at the early stages, at the preliminary investigatory stages, or was this a time when the prosecutor had a full understanding of the scope of the charges, full understanding of all of the individuals that may or may not be involved? The trial court can then weigh those and decide similarity of motive under the text of 804B1.
Isn't there, ultimately, though, the government's burden here, when you're talking about the witness who is the key witness, I'm not sure I understand your distinction between having to show probable cause at the grand jury stage and ultimately the sufficiency of the evidence. Aren't they really going to have to kind of go down the elements and check them off with this particular witness?
Well, Your Honor, the lower burden of proof had an effect on the prosecutor's behavior in this case, especially in the first grand jury testimony. In the record states
Aren't you
that,
kind of speculating about that? I mean, isn't your position a little bit speculative about why the government or the prosecutor did or didn't ask these
Your Honor,
questions? I'm trying to look at it more from a bigger picture as to what their motive was generally with this witness.
Yes, Your Honor. The record does state that the prosecutor believed that the evidence he had adduced at the grand jury testimony, simply placing the relevant parties at the birthday party together, was enough to secure an indictment. Now that, it's our position that statement in the record shows that the prosecutor was aware of this lower burden of proof, simply putting them at the party. That wouldn't be enough for a conviction at trial. Your Honor, with my remaining time, I would respectfully request that this court reverse the Court of Appeals decision because the prosecutor's motive at the grand jury proceedings was fundamentally investigatory and preliminary in nature. And a narrow interpretation of 804B1 protects the grand jury proceeding and protects reliability of the evidence adduced at trial. Thank you.
No, you still have at least another minute. What would you say? You read Stevens' dissent in
Yes.
Salerno? Stevens says you can't consider the fact the government might want secrecy. How would your rule, would you win even under Stevens' dissent in Salerno?
Your Honor, we would not win under Stevens' dissent in Salerno.
Okay.
And I see my time is up. May I respond to your question briefly? Or
Please.
Your Honor, we would not win under Justice Stevens' dissent in Salerno. And the last thing I would add is that there is no indication that that the government has procured the absence of this witness. There is no, this is a two-way street in one sense. Both parties now have to go forward without this testimony. And there's no foul play or anything like that afoot here. Thank you, Your Honor.
Thank you. Proceed when you're ready.
Mr. Chief Justice, and may it please the court, my name is Casey Klekas, and I represent the respondent, Ms. Dana Dinafrio. There are two issues before the court today. My co-counsel, William Hauptman, will address the federal rule of evidence issue, and I will address tipper-tippee liability. In this case, the government is seeking to assign criminal liability to a remote tippee. Unlike the cases that petitioner cited that involved a direct participant in a civil action, this is a criminal case, and the respondent had no knowledge of any wrongdoing. We respectfully ask this court affirm the Court of Appeals for two reasons. First, the Court of Appeals correctly held that the insider in this case received no personal benefit as defined by this court in Dirks. Second, there is no evidence that respondent had any knowledge.
Received no, but we in Dirks, we said it could be indirect and it could be future, including just reputational benefit.
Yes, Your Honor.
So you're saying there's no evidence that the jury could have inferred that Alex saying, hey, I'm going to do you a favor, and they're in an investment club together, and they're in New York, and their families are exchanging loans. He didn't expect any future. The jury couldn't infer that that was enough he would get some future benefit?
Your Honor, I do not agree with you. I think the important point here is that neither Mr. Abernethy nor Mr. Bookwalter actually profited from that exchange. Neither owned stock in iTech.
But it's clear, we said in Dirks, it's not just quid pro quo at the time. It could contemplate any future reputational benefit. And you're not relitigating the jury verdict, right? You're telling us the jury instruction given here was legally wrong.
Yes, Your Honor.
Correct? So I'm asking you, what instruction did Judge Brennan give that's inconsistent with what language in Dirks only? Don't put aside the Second Circuit and Newman. What language in Dirks is inconsistent with the instruction that Brennan gave?
In Dirks, it said specifically a reputational benefit that will translate into future earnings. Not that has the potential to translate, that will translate into future earnings. And going to the Dirks.
But what did the Ninth Circuit say? What was the italicized language the Ninth Circuit gave from our decision? You probably know it, right?
United States v. Salmon.
Yes.
Yes, Your Honor.
What was the language they italicized that the Second Circuit overlooked? It wasn't just reputational, it was?
The gift liability. Your
Yes.
Honor. However, I think we should follow the Second Circuit in this regard, Your Honor. They properly construed this court's opinion in Dirks. What they said was, first we asked, was there a pecuniary gain? In this case, there's no evidence of any immediate pecuniary gain. Second, we look at the quality of the relationship. That's important here. The quality of the relationship will determine whether we have casual acquaintances, where we might have a future quid pro quo, as this court described as the reputational benefit in Dirks. In that case, we would need something more, something objective, something consequential in the exchange. Otherwise, if the relationship is meaningfully close, then we can move on to the gift liability analysis.
So you say we should move Dirks to Newman. You think the Second Circuit got it right? Rakoff got it wrong?
I think the Second Circuit got it right in its context, Your Honor. And I think.
But they've got a three-part test. First, it's got to be a meaningful relationship, whatever meaningful means. Then it's got to relate to consequential exchange, whatever consequential means. And then it's got to relate to potential pecuniary gain. Meaningful, consequential, that's the legal standard you'd like us to announce?
That's the legal standard in Newman, Your Honor. And in
Is that the one you're urging us to apply?
I think a broad interpretation of Newman might go too far, as Judge Rakoff indeed said in United States v. Salmon. However, Newman does not need to go that far. What Newman is concerned about specifically is criminal prosecutions of remote tippees who have little or no knowledge of any actual wrongdoing. As I said, with the gift liability, we can only infer an intent to benefit if the relationship is meaningfully close. In Salmon, we had two brothers who ran an insider trading ring for a number of years, who saw each other every day, it said in the record, and we're in a tightly knit family. That's sufficient for a meaningfully close relationship.
Yeah, but wasn't it just kind of like this case in that one brother is doing a favor for the other brother? And I think the favor being the language that we have in the record here. We have a cousin doing a favor for another cousin, but not necessarily benefiting from that.
I agree
Isn't
with you.
that the case there? Weren't there two brothers and the tipper did not benefit financially or otherwise? Unless you talk about the warm and fuzzy feeling maybe you get when you do somebody a favor.
That's correct, Your Honor. And as this court was careful to specify in Dirks, that intent to benefit analysis is important. Otherwise, as the government suggests and tells us, we could have people washing their hands simply because they had a relative who they intended to benefit. As this court said in Dirks, it would resemble trading by the insider himself and a gift of the profits to that relative. However, we did not have that here. We don't have a meaningfully close relationship. What we have are two cousins. They saw each other, as it says clearly in the record, 3 times a year at most, only at obligatory family gatherings. And every time they met, they spoke about familiar and easy topics. How's work? How are things at iTech? And that is the basis of why we're here today.
No, well, Corrine says, hey, I have it on good authority that you should sell it now. Why wouldn't that be, well, I guess this is shifting to the scienter question. You want us to say guilt only if actual knowledge of the original insider? But if you're told by another hedge fund person, hey, I've got it on good authority, sell now, why doesn't that reach reckless disregard, willful blindness, whatever you want to call it, a perfectly normal fraud statute scienter level?
Your Honor, I think it's important to remember that Ms. Dina Frio, the respondent, was already considering in the recent weeks selling her iTech stock. She had already done her homework in a way. She was already leaning towards selling, and when she heard this from Ms. Kuzik, it was the last straw on the camel's back that all she needed to do was sell her stocks. And if I may continue, Your Honor, in this field, we have expert traders who rely on tips of information almost every day, and they need to make snap judgments to succeed in our nation's bustling security markets. So when she got that tip, that was all she needed. She didn't need to taxingly verify the source of the information.
But you are asking us to impose an actual knowledge standard, aren't you?
I think that's the proper holding, Your Honor. However, even in this case, she didn't have the should-know knowledge as this
What
court.
other federal fraud statute requires actual knowledge instead of constructive?
I'm not aware of that. I'm not aware of the answer to that, Your Honor.
Could I ask you a question about your even-if approach? And I saw this in the briefs as well. We had a judge instructing a jury that they could convict on the basis of negligence, basically, reasonably should. If that's wrong, what difference does it make what the evidence was? Or maybe it does, but explain to me why. You're going back to telling me there was no evidence of this, there was evidence of this. But isn't the fundamental issue, as posed by Judge Higginson here, the question of whether the jury was wrongly instructed?
Yes, Your Honor. That is the question before the court today.
And we don't have a sufficiency of the evidence question before us, do we?
No, Your Honor. We're talking about a de novo review of jury instructions and whether those instructions were proper under Dirks v. SEC. Speaking of the constructive knowledge requirement, like I said, she didn't even have that constructive knowledge. There's nothing to indicate that she should have known or should have verified the source of her information. In any case, we shouldn't allow for it in this case. Dirks was a civil case. It dealt with a breach of a fiduciary duty, what constituted a breach, whereas in this case, we're dealing with criminal liability, and the government is hanging its hat on a single sentence in Dirk that says should know. We don't think that's sufficient in this case, but like I said, even if this court doesn't decide to go that far, the respondent still wins. If I could go back to the personal benefit analysis. Under Dirks, as I said, this court laid out that a tippee is liable only derivatively, a tippee is liable only derivatively if a tipper is first found liable. The tipper must have breached a fiduciary duty. In breaching that fiduciary duty, he or she discloses material non-public information for a personal benefit. As I said, there's three different personal benefits in this case. Regarding the Judge Higginson, you asked about the quid pro quo, and I wanted to return to that for a minute.
Well, I guess I'm more worried about what exactly is the rule you're asking us to announce. You want us to clean up that stray language about should have known and make it actual knowledge. And you want to tighten up the personal benefit to be pecuniary in nature. Second Circuit did both in Newman. What I'm worried about is, well, then that creates an incentive for people to create the longest possible chain. So if you're the fraudulent insider, you just tell enough casual acquaintances so that you have plausible deniability, and the eventual person who reaps in. How much did your client save for her company in this case?
My client, Ms. Dina Frio, made $3 million off.
$3 million off this early sale. The information wasn't public yet. So we want the SEC to scrutinize. And they say, oh, look who she was with, someone who told her to sell quickly. Who was that person with? Oh, the insider, the officer. There's got to be, so how does your rule have a limiting principle so that people who are in collaboration would still face liability?
Yes, Your Honor. I want to respond in a few ways. First, speaking of what Ms. Dina Frio actually knew in this case, again, she didn't know the source of the information nor the nature of a personal benefit which is required. Second, it's also important to remember that the SEC still files civil actions all the time and imposes heavy penalties that might be able to catch up what the government wants to do here, which is a constructive knowledge requirement. Our ideal holding, Your Honor, as you asked, is that this court require the actual knowledge requirement such that, let me rephrase, an actual knowledge requirement as to the quality of the relationship. Therefore, a constructive knowledge requirement might be sufficient that if she already knows if she knows the quality of the relationship, has actual knowledge of such, then she might have constructive knowledge as to the intent to benefit analysis.
It seems like that's just a fact question. It'd be hard to construct a rule that would incorporate that, wouldn't it?
I don't think so, Your Honor. I think if we follow the three prongs of our personal benefit analysis, and then we look to the knowledge analysis of whether the respondent had knowledge not only of the breach, but knowledge of the personal benefit specific to the government's charge. That would entail knowledge of the source of the information, of which respondent has no knowledge.
Well, respondent was told good authority, and respondent knew they'd all been together at a party.
Yes, Your Honor. However, she did not know that anybody at that party worked at ITEC, let alone that the information passed from Mr. Abernethy to Mr. Bookwalter, and then Ms. Kuzik, and then to respondent.
It's an unusual case where multiple government witnesses die, so we can't tie it up that way.
Or become demented.
True.
And we become demented. I mean,
I'm sorry, was that a question, Your Honor? As I said, Your Honor, in any case, we shouldn't allow for the constructive knowledge requirement here because this is a criminal case. We're not dealing with a direct participant. We're dealing with a remote tippee, and that's important to remember. In the United States v. Salmon out of the Ninth Circuit, as I mentioned, we had two brothers who were very close, and then we had one tippee who, Mr. Salmon, the defendant, who married into that family, who knew exactly how close those brothers were. And therefore, there was a meaningfully close relationship, such that he should have known. And in fact, in that case, he did know because he was told that the insider brother, did it to benefit his brother, the tippee. Conversely, in the United States v. Salmon, there were two lengthy tippee chains like there are here. There was the defendants in those cases were at least 3 or 4 levels removed from the actual insider in that case. As the court said in that case, a casual acquaintance, which is essentially the same thing as we have here, is not sufficient for a gift liability. And that's, as you mentioned, Justice Coates, that's what was so unclear in the jury instructions, that they could say that we have a casual acquaintance and that there could be an intent to benefit. We don't think that's correct, Your Honor.
did you by chance look at the oral argument for the Dirks case?
Yes, Your Honor.
Do you remember the SEC lawyer, Gonzon? Is that his name?
I don't remember specifically.
He's asked, how far down the chain can the government go? How far down to tippees does the SEC expect? And his response is, well, if if you find a crime, discover a crime, and you're heading to the police to report it, but on the way you take a little bit, you would be exposed. As long as you knew there was an original thief of the information, you should be liable.
I believe that's correct, Your Honor.
But that's exactly what your client did. She got the inside information. She profited immensely herself without making it public information.
But if we back up just a second, Your Honor, we're forgetting the scienter requirement where she did not have actual or the should have known knowledge.
Well, the jury said she should have known.
I believe they said that under improper jury instructions, Your Honor, and that she should have known that the two were close, and then the district court talked about reading the tea leaves, about the loan from Mr. Abernethy's mother to Mr. Bookwalter's mother, and how that played into it, and simply the jury instructions were wrong and misleading in this case. Now, with my remaining, may I continue, Your Honor? Okay. My remaining time, the government should be wary of over-criminalizing in this case. There are, in trading in particular, pardon me, Your Honor?
No.
Sorry. In trading, traders rely on snap judgments every day, as I said, and we don't want to overburden them with taxingly having to verify the source of every tip or information they received. So with that, thank you, Your Honor. We respectfully ask this court affirm the Court of Appeals.
Mr. Chief Justice, and may it please the court, my name is Will Hopman, and I represent the respondent.
Before you get too deeply into your argument, Mr. Hauptman, I want to point out to you, if you hadn't noticed, you will get a split-second warning with that yellow light. That is all. So monitor your time accordingly.
Yes, Your Honor. I'm going to discuss the proper construction of Federal Rule of Evidence 804b1, specifically the motive requirement. Appellate courts review evidentiary rulings for an abuse of discretion. However, they review the construction of those rules de novo. This court should affirm the 13th Circuit's construction for two reasons. First, the 13th Circuit properly construed Rule 804b1, and its factual inquiry as to the government's motive contained factors sufficient to determine that the government's motive to discredit Mr. Abernethy's testimony was indeed similar as it would have been at trial. Second, the government here had a similar motive to develop the grand jury testimony, even if this court adopts a more limiting construction of the rule, such as those endorsed by the Second and First Circuits. Now, Your Honors, to the first point, the 13th Circuit considered factors sufficient to determine that the motive was indeed similar. The 13th Circuit relied primarily on two factors, the first of which was the government's strong commitment to prosecute, the second of which was that the government was investigating the same underlying conduct that it would later have to prove at trial. Justice Blackmun, concurring in United States against Salerno, noted that the inquiry into the construction and application of this rule is necessarily factually based. These factors here are sufficient to determine that the motive was indeed similar.
But if it's fact-based, the district court's in the best position to do it. He said he made the ruling and the government got it out. So what's the Third Circuit? Did they find that he made a clear error in his fact-based ruling?
Your Honor, the district court abused its discretion in its application of the rule.
But abused it in what way? Clear error as to fact or made a legal error? And if he made a legal error, what was the legal error?
Both, Your Honor. The legal error was that the district court, quoting a dicta from the Second Circuit de Napoli case, said that the motive must be substantially similar. However, as to the factual side, it only looked at one factor. As the government argued, it looked to the factor that the nature of a grand jury proceeding is investigatory as opposed to adversarial as it is at trial. The Second Circuit in de Napoli looked at several other factors in a very fact-intensive inquiry. Thus, the district court, which looked only at one factor and based its legal guidance on dicta in the case, both erred as a matter of law and looked at insufficient.
How many questions did the government ask in grand jury that were impeaching in nature? More than a dozen hours of questions, or one or two?
Excuse me?
How many impeaching questions did the government ask Alex?
Well, the government asked Alex first whether he knew Ms. Dinafrino or Ms. Cusick, and then at the second go-around, it asked whether he received a personal benefit.
That doesn't sound very impeaching. In Salerno, there were 400 pages of transcript cross-examination, right?
That's correct, Your Honor.
So here, it's just 1 or 2 pages. It looks like it's a really early grand jury investigation. They say to him, hey, did you benefit? No, I didn't benefit. Who'd you know? Didn't know people. Then they stop.
Your Honor, it's important to look at the underlying motive rather than the actual exchange, as Justice Stevens noted in his dissenting opinion in Salerno. Moreover, the record...
Well, but stop there. You're relying on a dissent in a case where it was 8-1? That's your best authority, that we should follow Stevens' advice?
No, Your Honor, it's not the best authority. However, it is persuasive in that the court in that case remanded and unfortunately did not have a full opportunity to explore the rule. Moreover, the record clearly reflects...
But on remand in that case, it was kept out again.
That's correct, Your Honor. Using a many-factor, they looked at many facts pertinent to the government's motive and determined then in DiNapoli that the testimony was properly kept out. The district court here relied on one fact, and that fact is simply insufficient to determine that the motive was indeed similar. There are many facts that can go into such an analysis, and the respondent does not suggest that you adopt a one-size-fits-all rule. However, it is necessarily a factual inquiry, and the district court did not here meet its burden of demonstrating that it considered multiple factors. So the first factor that the 13th Circuit considered was that the government had a strong...
Could I interrupt you just 1 second there? We keep talking about alternate opinions, dissenting opinions, concurring opinions. It's clearly a factual matter. Are we relying only on a concurring opinion, even for this general proposition that it's primarily a factual matter? Or am I missing something?
Your Honor, the court in Salerno held that the courts must indeed find there was a similar motive without expanding much further. However, to find that it is similar, it necessarily requires the district court to look into many factors. The circuit courts that have had more opportunity to explore the proper construction and application of Rule 804b1 have given some very persuasive guidance as to how this approach can occur. And the 13th Circuit, in this case, looking at the 2 factors, the government's commitment to prosecute and that the government was investigating the same underlying conduct that it would have to prove at trial, is a good example of how to properly approach this rule to demonstrate that the motive was similar.
And so basically I hear you saying that as far as we're concerned, we haven't really decided much of anything about these issues. We've decided generally about similar motive. But aside from that, even though we're not actually bound by our own precedent, and that's a matter of discretion, we haven't even actually addressed these. So all of these things you're posing to us from alternate opinions, whether it be a dissent that you find persuasive or a concurring opinion, are things that you think we should find persuasive in terms of construing this rule. Is that right?
That is correct, Your Honor.
Okay.
Sort of fleshing it out is what you're saying?
We're shooting from the hip. So the government's commitment here to prosecute was strong. It had 2 targets, Ms. Cusick and Ms. Dinafrino. And as the record indicates, the prosecutor's aim in questioning Mr. Abernathy was to obtain an indictment against both of those witnesses. Now, especially for the second time Mr. Abernathy testified before the grand jury, and that was after the grand jury returned no indictment against the other witness, Ms. Cusick. The government was at its last target. It had 1 shot, and that was to return an indictment against Ms. Dinafrino.
What if they're trying to flip him still? What if they've got him in the grand jury, they want the guy to cooperate? Why would they want to then discredit him?
Well, Your Honor, being that the government was targeting Ms. Dinafrino,
Right?
if it wished to flip Mr. Abernathy and have him cooperate, it could perhaps offer a grant of immunity, offer to not prosecute in return for his cooperation against the target witness, Ms. Dinafrino.
Right, and if you'd done that, that would be Salerno, you're in better footing, right? Because then you got to believe he's telling the truth. But here he isn't immunized. And so why would they want to discredit him if they're still trying to get him to cooperate?
Well, as the district court found, the government's case was largely circumstantial. They had little evidence with which they could discredit Ms. Dina Frio or Ms. Cusick, and Mr. Abernathy, in fact, twice testified in such a way that cut against both elements that the government would have to prove at trial, the knowledge and the personal benefit. Thus, it had a strong motive to discredit, and many of the circuit courts have noted that when the witness testifying before the grand jury discredits the government's theory of the case or other witnesses, the government's motive to discredit that testimony is heightened, especially in light of the circumstantial case, which is what we had at this case at bar. And moreover, being that the government was
Grand jury secrecy doesn't apply to the witness. So when he walks out of the grand jury room, he can call up his friends, right? And say exactly what they asked him. So why wouldn't the government not want to reveal its prosecutorial plan to him with impeachment? Because he could walk out and call people.
Yes, he could, Your Honor. And again, we must look at the exchange, the motive, rather than the actual exchange that took place. And given the facts of this case, the government did indeed have a strong motive. It was investigating the same underlying conduct that it would have to prove at trial. And we know from Dirks against SEC that the government would have to prove first that Dina Frio knew that she received information disclosed in breach of a fiduciary duty, and second, that Abernathy received some sort of personal benefit from doing so. We know from the Fifth Circuit in Battle Memorial Hospital that when the government is litigating the same side and the same issue, it has a heightened motive to discredit testimony that cuts against its case. Moreover, being that Abernathy testified twice as to matters that undercut the government's general theory, it had a strong motive to discredit Abernathy in any way possible, and it bears, we must reinforce that the government had not yet returned an indictment. The grand jury had not yet returned an indictment against Ms. Dina Frio. The government had no indication as to whether the grand jury was satisfied that the government met its burden of convincing them by a preponderance of evidence that Ms. Dina Frio was involved in some sort of criminal conduct. And moreover, Your Honors, the 13th Circuit's construction is consistent with the plain meaning of Rule 804b1, which requires that the party against whom hearsay testimony is later offered had a similar motive to develop that testimony in the previous proceeding. And as this court noted in Bergeli against the United States, the plain meaning of the words in the rules is the best evidence of their proper construction. Indeed, Justice Blackmun, concurring in Salerno, noted that a similar motive does not mean identical motive.
Is there a split out there? I know you don't favor DiNapoli, but is there a circuit that you think really, is there a real contradiction out there that we have to clean up?
It's not so much a split as a difference in the intensity with which the courts treat the facts. The First Circuit in United States against Omar and the Second Circuit in DiNapoli use a very fact-sensitive inquiry that considers many factors in its determination as to whether the motive was similar, whereas the other courts that have considered this issue look at the motive with high generality or considering perhaps 2 or 3 factors. Here, the 13th Circuit construction easily satisfies the test used by those circuits that have a lighter burden, if you will. But however, it considers factors that are sufficient to satisfy a stricter approach, such as that used by the Second Circuit. Additionally, factors are present that were not discussed by the 13th Circuit that would also indicate the government's motive was sufficiently similar, such that the testimony was properly admissible.
Can I ask you a kind of a broad question here? Do you think that there are any constitutional limitations on how lightly or broadly, however you want to describe that, we could construe this rule? And I'm thinking particularly about the world, a lot of the cases you all cite are before it, but about the world since Justice Scalia turned confrontation upside down in Crawford. Is there anything that would not, under your construction of the rule, possibly satisfy the constitutional requirement of an adequate substitute for cross-examination at trial? Or is that question sufficiently confusing that
Your Honor, the purpose of the rule against hearsay is to prohibit the use of unreliable evidence, and given a defendant's constitutional guarantee to present his or her defense, it's important to balance appropriately the reliability of hearsay evidence with the potential of introducing unreliable testimony that could mislead or confuse the jury. Here, a limited construction of Rule 804b1 would invade the province of the jury to find the facts, because it would give the prosecutor much more say in what testimony is truthful and what should be admissible. If the government chooses to not discredit a witness, saying that its motive was investigatory rather than adversarial, it puts the ball in the prosecutor's court in that it prevents the defendant from introducing probative and relevant evidence that tends to be exculpatory, and it keeps that evidence from being evaluated by the jury.
But there's no ball in the government's court. You're asking for the asymmetrical rule. Let's say the guy says something incriminating. Crawford clearly keeps that out. If he's unavailable, right, a grand jury's testimonial, the government will never get it in. So you want a one-way rule. If the exculpatory statement's made in the grand jury, you still want to get it in. But the government's never going to get symmetry here.
Well, Your Honor, the government tends to want to keep more evidence in, and it seems strange that the court might construe this rule in a way that would prevent the defense from getting exculpatory evidence. The Crawford concerns aside, this is the construction of a rule, and primarily it relates to the application of the rule against hearsay and the extent to which its exceptions should admit evidence from a non-testifying witness. So adopting a restricted interpretation of Rule 804b1 creates many problems, some of which we have just touched on. It creates an incentive to not cross-examine witnesses in hopes that the government could later keep their testimony out, and it gives too much power to the prosecutors. Now, Your Honors, I see that I'm running out of time. I will briefly touch on one issue before concluding. Even if this court adopts a more stringent rule, such as that endorsed by the Second and First Circuit, the respondent's case is still meritorious. First, Abernathy's testimony tended to exculpate Dina Frio and was uncontradicted. And second, the grand jury had not yet returned an indictment against Dina Frio. Both of these factors strongly counsel in favor of a finding that the government's motive was similar, and the district court abused its discretion by not examining those factors. Thus, because the 13th Circuit properly construed Rule 804b1 and because the government's motive was similar even under a more limiting standard, we respectfully request that this court affirm. Thank you.
Thank you. I'm not sure how time stands, but as we're doing this competition, there are several minutes for rebuttal. Is that right?
That's correct.
Okay.
Your Honors, Mr. Chief Justice, I'd like to use my time for rebuttal to confront one of the major issues that seems to be at stake with regards to my issue, the tipper liability. Your Honor brought it up in respondent's case in chief, seems to focus on it as the potential for over-criminalization of financial traders. And I would just note to that is that we already have the ultimate safeguards for that. We have the jury trial, and we have the government's responsibility to prove its case beyond a reasonable doubt.
Do you know, I think I'm correct when I say that the Southern District of New York had never lost an insider trading case until Newman. So that does sound like overcriminalization. They'd never lost until the Second Circuit said, we might need a little tighter scienter standard here.
Your Honor, I don't know if that's the primary reason why the Second Circuit ruled the way it did in Newman. I would, if you're asking,
you're saying their Newman rule may prevent criminalization of things that have to be criminalized. It doesn't sound like the government had any trouble up until that moment.
Our contention is, yes, that the Newman standard varies from the Dirk standard that this court articulated.
And it's too restrictive.
It is too restrictive, Your Honor. However, the facts of this case are significantly different than the facts in Newman. In Newman, the tipper and the tippee, the defendant tippee, were 4 to 5 levels removed from the original tip. In this case, the respondent is only one person or 2 people removed from the tip. Also, she received information that she reasonably should have known was part of a breach of a fiduciary duty, when in Newman specifically distinguished that the defendant had no reason to know that that information was confidential. And Your Honors, this court articulated in Dirks a standard for district courts across this country to use when giving that jury that I was speaking of the instructions when it comes to this issue. And criminal cases across this country have used this Dirks standard. So the distinction between civil and criminal was not material, and it's not there's no reason today to overturn it on those grounds. Cases from the First Circuit in Sargent, or the Second Circuit in Zhao, or the Ninth Circuit in Salmon, all criminal cases have used the Dirks jury instructions with regards to this issue. And the government's position is that this case does not provide an opportunity to overturn this court's ruling from Dirks over 30 years ago. So for those reasons, we ask that you reverse the ruling of the 13th Circuit and affirm the district court's decision with regards to this issue. Thank you.
Thank you.
Brief rebuttal, Your Honor. I'd like to make 2 points on rebuttal. Respondent has stated that the prosecution had a strong commitment to prosecute, and therefore that the motive to discredit was high. However, given the lower burden of proof required grand jury proceedings, the prosecutor did not have a high motive to discredit. In fact, at the second grand jury testimony, where the witness, Mr. Abernathy, stated things that could be adverse to the prosecutor's case at trial, still secured an indictment without discrediting the witness's statements in that case. Second, Justice Higginson, as you mentioned, as you questioned, we don't believe that there is a fundamental circuit split on this issue. And this gets to the idea that this is a fundamentally fact inquiry. And Justice Coates, your question regarding what other courts have stated whether this is a factual inquiry, there are other circuit opinions that have noted, DiNapoli notes this is a fundamentally fact inquiry, and of course not binding on this case, on this court. However, this gets to the idea that the facts are important and the district court is in the best position to make these decisions.
So this is just a fact-specific case. There's no tension out there in the courts.
There is a tension, Your Honor, between a broad and narrow interpretation, but not a fundamental circuit split in the application of the law.
There are leading scholars that help us understand. You went to CU, right?
Yes, Your Honor.
To Professor Mueller, has he spoken on Salerno? And
yes, Your Honor.
And what you took his class, I'm sure.
Did, Your Honor.
What did he say about this issue?
I don't recall, Your Honor. Your Honor, there is a tension here, and that is between a broad and narrow interpretation of 804b1. And that gets to the issue.
How do we help our lower courts with that tension? How do we help them?
By announcing a narrow construction of 804b1, a narrow fact-specific construction under 804b1. And the narrow construction is what this court should adopt today because it's already an exception to the bedrock rule against hearsay. This court's decision today should not broaden that exception for fear of admitting unreliable hearsay at trial. For those reasons, we respectfully request that this court reverse the Court of Appeals decision allowing admission of this testimony. Thank you.
Thank you. Counsel, we appreciate all of your arguments. And having nothing else on the docket, this case will stand submitted, and I'll ask the bailiff to announce a recess.
All rise. Thank you. You'd all be seated. I would ask you, everybody, to thank their presenters. Very impressive. You all did a fantastic job. Super hot bench. For those of you who are here, maybe watching their first appellate argument ever. This level of discourse between attorney and judge really shows how much work goes into this. It is unbelievable the amount of time that it takes listening to oral arguments, referencing cases, in multiple jurisdictions, and it is just unbelievably impressive this year to see the judges, the justices, how much work they have put in to this. And so anybody who this is their first oral argument, you got a really good taste for what a real argument sounds like. And the quality that the students here have, some 2Ls, a 3L, show you how much I think people move from 1L year to 2L year and 3L year, how much you really mature and develop. And I think we sort of live in a time in which word salad constantly is, we're exposed to, where people just sort of talk about things and it makes no sense. But you see here how the craft of lawyering is in fact putting together really complex ideas, lots of information, and being able to distill that and then enter into discourse with judges about where to go in terms of policy or to resolve tensions. And so, this was a real treat, and I hope people, think about that as you go to the reception later today. But right now, while the judges deliberate, we usually open this up to if anybody has questions for the competitors so that they can sort of exhale and tell you, if you have questions of them. So, again, thank you. All four of you did an outstanding job. I'm very impressed, as I'm sure everybody else is. Does anybody have any questions for the competitors? Yes.
About how many cases did you read and know well enough to be able to answer questions?
Know well enough? I would say, I don't know, 8 to 10. Read many more, but know well enough.
I have a list here. It's like 8 cases that I thought might come up, so there's one thing.
Yeah, I read maybe about 20, probably relied on 12 in my brief, and then knew 6 to 8 really well for oral argument.
Yeah, it's probably the same with me. Maybe a dozen. I really did listen to the oral argument.
Yeah,
Other questions? Yes, sorry.
How many of those questions the judges were asking came out of left field for you guys, and how much of it would you broadly expected?
I'd say like more than half were definitely like I'd almost never considered, and we were racking our brains after that.
Yeah, it's kind of the same for me, I think. There were a couple where I don't really never thought about it before, so that was interesting.
Yeah, the Crawford question caught me off guard. I have no idea what I said. I hope I
The Mueller question, obviously.
I didn't know if he was here.
Yes.
What piece of advice do you have for one-ls who are just starting to learn about oral argument but are interested in getting involved with the court?
Thank you. It's a great softball question. Experiential learning. Dylan.
Well, I think actually before you do your 1L argument, just like finding videos on YouTube of people doing oral argument, things like that, that's going to be really helpful. Actually, better just read about it and see it in person and listen to it. And then obviously try and take advantage of as many opportunities during the 2L year that you can to start moving more beyond your legal writing class. The first competition in the fall here at school, and then traveling competitions after that.
Yeah, I would say substantively, rather not just like getting involved, which I think is really important, and everybody should get involved with this competition next year. I think it's a lot of fun. But I think knowing the cases really, really well and knowing the record really, really well are like kind of just bedrock principles for oral arguments. You have to be comfortable talking about it. Sometimes you'll get a question that you're not comfortable talking about, even if you know it really well. But Casey and I, for all of our oral arguments, we've kind of gotten in this routine where we basically just sit in a room together for like an afternoon and just lob questions at each other and just kind of like work our way through the issue that way. And it's really great to have someone like Casey who can like push back on the arguments and challenge them that way. So something like that I think is super helpful too.
And 3 of us took advanced appellate advocacy with Professor Mack, and that was a really great course. Additionally, many of us competed in the CAC, the Colorado Appellate Advocacy Competition. So there are a lot of opportunities if you want to explore something, just find someone to be on your team, and it's not a really serious time commitment. You get a credit for it, so I've enjoyed all of the ones that I've worked on.
The only thing I would add to that is like really take advantage of your first year experience that you'll have in this. Like in Professor Brower's class, it's like an unforgettable experience. It's one of my favorite afternoons. If you do it down in the federal courthouse, I hope that's still the case. Not the case. I hope it's the case. And that was great. And just practicing as many times as possible, just to see if you're really interested in it. Because if you can do it, it's something better.
I'll take a little point of privilege here. Sometimes there is actually the arguments for the 10th Circuit or the Colorado Supreme Court are held here on campus. Make sure that you attend that if that happens. And, you know, we're lucky with proximity to the 10th Circuit or the Supreme Court or the Court of Appeals for you during your time in law school to go and observe. And the best way is to watch other lawyers make arguments and then learn how to do it from there. Just to sort of piggyback on the competitions, you know, right out of the gate in your second year, there's the announcement to participate in the Colorado Appellate Advocacy competition, the CAC. And, you know, we had 70-some students compete in it last year. There were 45, 48 students who competed this year. Once you participate in that, you become eligible to compete in the external competitions that are listed in your program. You see some of the teams there. So I would say that, you know, for a 1L, is as you think about planning your fall and you think about your spring of next year, and this is something that interests you, think about how CAC fits in, and then how that will allow you to participate in Barrister's Council, in moot court, mock trial, transactional, and how then you can go and represent CU in competitions around the country. I'm going to go ahead and knock on the door and just ask how long more. But is there another question? Any other? Yes, sir.
Yeah, what did your reference materials at the podium look like?
I had a table of cases with the case name, facts, holding, and reasoning. Just pretty bare bones stuff, and then an outline that had my main points and some notes as to things I really wanted to hit on.
Definitely think it's better to have less. I kind of change it up every time. I try note cards, and you have a few things on note card, and then if you finish it, you flip it over. Worked better last time, I think.
Any other questions? All right, well, hopefully momentarily we'll have, ready? Okay, all rise.
Thank you. Please sit down. Well, now that we're wearing our real clothes, we had to check our phones to make sure they were off and stuff like that. Well, we've made some quick decisions, and I'll let everybody speak, but let me just say it's a lot of fun doing this, and you all really prepare nicely, and you do a whale of a good job, so I'm not sure. Well, we'd like to give the top prize to everybody every time, but the competition wouldn't be any fun if we did that. So we've picked a team and one oralist. And maybe I'll go ahead and make that announcement, and then we'll get a chance to speak and say a little bit what we had thoughts. We didn't flip a coin, but it's so hard to make a choice. You should all feel complimented, but we decided, we thought the government had the better side of this one, the presentation, and particularly as an oralist, Mr. Ball. We were going to settle on you. And maybe I'll let my colleagues start out if they have some comments they'd like to make. Judge Higginson?
Well, what you might not realize, I mean, I've been on the bench for 5 years, is that I'm more nervous now as a judge when I ask than as I was when I was an attorney, because you prepare one case, but for us to be able to penetrate, for me to be able to penetrate to a level that gets anywhere, I've got to prepare cases so well. And you guys, all of you were like that. I thought each of you showed a lot of sophistication. I'll just say quickly, Dylan, I thought you were going to sort of cling to Dirks. And just say that's it and not be able to move, but instead you moved between that law and facts and policy and excellently. So you moved across sort of different persuasive authorities really well. Andy, you're going to know why I thought you did well, because I had the district court ruling upside down, but you were so gentle back that probably the audience didn't even realize it when you corrected me. And that's a real lawyer's trait. I'm guessing you would wish that the Supreme Court hadn't decided Salerno the way it did, just because the government's instinct starts to talk about structural things so much. But you did excellently, and specific things that I thought you were good to just flat out tell us, under Stevens' dissent, we would lose. It's really good when a lawyer can concede things that aren't fatal. And you were very careful about the Brady question. Well, would this rule even trump due process stuff? On the respondent side, Casey, this case, when you think about it substantively, is sort of a defense attorney's dream, because everyone is dying or getting demented. And the government then's got to reach a lot. You, I thought, were excellent. Alvin Rubin on our court, who's a pretty legendary judge, he sort of stressed that you want to create a theme that's like a melody a judge is going to want to sing in the shower when they wake up. And you had a terrific moment where I said, well, could you tell me the italicized language the Ninth Circuit said? And you knew it right ahead. And you just filled it right in verbatim. So fantastic case preparation that way. I also like that you didn't just wholeheartedly embrace the three-part Newman test. I think it's a really difficult test. So you said, well, we wouldn't have to go all that way. When I made my dead, demented remark, it plays to the crowd, and that wasn't smart. You probably don't want to then point out that I wasn't asking a question, but you were great, because that's how you need to humble federal judges, because there was no question. For a split second, I was thinking, Casey, get to your next point. This is embarrassing for me.
That was at least a little better than saying, was there a question in there somewhere?
Yeah. Will, there were just, phrases that you used that were beautiful, sort of lyrical, which I don't know if you rehearsed them. Some lawyers, they have this concept of rehearsed spontaneity. It seems like you just made it up there, but you've actually planned it. So you used a phrase about, well, it's not a direct split. It's just different intensity as to factors. That may have just flowed out, but that was just a beautiful little construct you came up with. So you kept great poise, and you've got an ability to answer with no, I was trying, you can see, I was just trying to dislodge you a little bit. I think you focused on the key facts, that he was in there for 2 grand juries, and the government lost the first one. They had every motive. I do think it's a tough case. Your issue was a hard one, because there isn't much cross-examination of this guy. It's just not like the cases, I don't think. So you had a tougher case to make, but you did it superbly.
Nancy, you want to?
Thank you. I've just judged a few moot courts, and I have to say I've never judged one that I thought was so evenly matched among the 4 of you. That was not an easy decision, either as to the winning team or as to the winning advocate or oralist. And I just want to say this is the hardest one I've ever judged, because you were all 4 superb in your knowledge of your positions and in your responses to questions. There just wasn't an obvious differential to me listening to the 4 of you. So I just want to commend you on that. I'd love to have any one of you appear in front of the 10th Circuit in a couple of years. I would be thrilled to have you argue in front of us. I would say just generally for the petitioners, because you have the advantage of rebuttal, that you could perhaps have used that a little bit more strongly, because you did have such intense questioning. That you might have been just a little bit more prepared to really say, wow, here was Judge Higginson's questions, and you played right to us, and bang, bang, bang. Here's why we want to respond in rebuttal to your questioning to the respondent. Just be more prepared to actually use it as a rebuttal as opposed to just a prepared remarks. You both did a little bit of that, but just be a little bit more fluid, I guess, is what I would say. And I thought it was I'm trying to remember who it was that I was kind of going down that whole sufficiency of the evidence question, and well, it was really Judge Higginson who brought us back to the fact that this really wasn't a sufficiency of the evidence case. And I want you to know that that happens a lot in oral argument, is one judge will sort of go down the path with the attorneys, and somebody needs to jump up and down on the other side and say, hey, you have this all wrong. This isn't about that. It's about the instructions. And while Judge Moort, your questions were fine, they were misfocused. And hopefully it isn't the judge that sets us back on, but don't ever be afraid to say that questioning was a little bit off in a very nice way because it wasn't focusing on what the issues are, which is the instructional error or whatever the issues are. Don't be afraid to say it was off base. And as far as humbling federal judges, I think that's a good point. I've participated in many discussions about when humor is appropriate, and I think the respondents both used a little bit more humor, and of course you've got a different crowd here than we normally have in a courtroom, so you got to take that into account, and you're playing to the crowd a little bit, but you have to be really careful with it because it might not play well depending on your judges. But I do understand our setting today, and I thought it worked out great for you. But just generally, I would really caution against using humor because it could be taken wrong. And of course, when the judges make jokes, everybody has to laugh, and that's sort of the unfairness of it all, but not always true on the other side. Just overall, I hate to even, I sound like I'm being critical. I'm not. I was incredibly impressed with the depth of your knowledge, and like Judge Higginson said, it's just amazing to me when you knew exactly what he was talking about, for instance, with the italicized portion of a dissent. And you said, well, yes, I do know that. And that's just amazing. And I guess I would leave you with, each of you, with the idea that each of you could have stood to be more confident because you clearly have it, and you could have thrown just a little bit more confidence and strength into your presentations because you do know what you're talking about, and you could tell us some things. So don't be afraid to do that, to show your confidence.
Okay. Well, I don't know that I have too much to add. I would like to join in and say I've always been in favor of picking on federal judges. State judges is, of course, another matter altogether. No, let me just, everybody's said specifics. I don't have too much to add there. Let me just offer as well. I thought as oralists, as speakers, you all did extremely well. Your presentation was great. I think you see it's a complicated form of argument that we do. I sometimes feel like it's almost sort of the highest form of rhetoric left in our culture because it's got this sort of forensic aspect, but also a deliberative aspect. You're asking us to decide whether what happened and whether something was according to rules, but at the same time you're asking us to make law. And I thought, and do policy that way. So I thought you all did a nice job, and I thought you if you didn't appreciate it before, I'm sure you do after an argument like this, even at your early career, the problem of time and the problem of not being able to lay out everything from scratch and figuring out how you get to your audience as quickly as you can and on the point. And I thought you all did an excellent job of moving to wherever we went, which sometimes you'll see advocates, especially early in their careers, not do. They're kind of prepared for a speech, and if the judge bothers them, they show their irritation. And I didn't think you all did that. So I'm probably not telling you anything you don't know, but I thought you were all quite excellent that way, and it was enjoyable having you argue to us. And I was just going to add, just as an anecdote, one of my colleagues suggested I mention this to you. I went to CU, and I went to CU Law School. I still referred to that other building as the new school because they built it while I was in school. But in the Rothgerber competition, I remember, we're all very young. The final was Justice White and Chief Judge Pringle of the Colorado Supreme Court, who was about a year or two from retirement, and Judge Doyle of the 10th Circuit, who had been on the Colorado Supreme Court and then on the District Court and then on the Circuit Court. So, and that was quite a panel to sit in front of. And the one thing I was going to say was, I watched that argument from way out there someplace because I didn't get past the first round of the Rothgerber competition. So, congratulations to you all, and thank you very much for your interest.
Before we retire to the Rothgerber reading room in the library, so you'll just go up the stairs.